Hi there. My name's Mark Watson. I'm a barrister at Mountford Chambers. I specialise in criminal defence and professional regulation. Mountford Chambers are a barristers' chambers that comprised of 6 King's Counsel and 39 junior barristers. Specifically in Chambers, we have a professional regulation team consisting of 26 barristers, King's Counsel and junior barristers together. And we're very lucky that Kingsley Napley are helping with our talks, and I have the excellent guest with me, Georgia Rose.
Thanks, Mark. It's very good to be here with you today. So my name's Georgia. I am a solicitor at Kingsley Napley. I specialise in healthcare regulation and primarily in representing doctors in fitness to practice proceedings brought by the General Medical Council.
Thanks. So today our webinar is an introduction to fitness to practice proceedings before the General Medical Council. And specifically, we're going to talk to you about 6 topics. The first one being, when will a concern be investigated by the GMC? Then how do I fund my defence? When will an interim order be made? How do you prepare for a final hearing? What actually happens at a final hearing? And finally, how is sanction decided if appropriate? And we're going to separate this into matters that I've got more experience with being a barrister and matters that Georgia's got more experience with being a solicitor. So over to Georgia.
Thanks, Mark. So the first question to address is, when will a concern be investigated by the GMC? The GMC will investigate a concern when it raises a question about whether a doctor is fit to practice. Doctors fit to practice if they are competent, practice safely, and do not pose a risk to the public, to the wider public interest, or to themselves. Doctors who are fit to practice establish and maintain effective relationships with patients, and they respect patients' autonomy. A doctor's own physical and mental health is also a factor that is considered by the GMC when deciding whether the doctor is fit to practice. When a doctor falls seriously short of any of these necessary qualities or requirements, that's when their fitness to practice might be found to be impaired. And I think it's important to take a step back when we consider what impaired fitness to practice actually means. And it's also useful to look at the purpose and functions of the GMC when considering this. I think we would all agree that doctors hold one of the most trusted positions in our society. We trust them to care for our health and our well-being, and we also trust them to care for our families and our loved ones. And because of that trusted position that they hold in our society, doctors are understandably held to certain professional standards and standards of conduct. These standards are set and they are monitored by the GMC. The GMC's primary purpose is, of course, to protect the public, and protection of the public includes 3 main aspects, which are protecting and promoting the health and safety and well-being of the public, promoting and maintaining public confidence in the medical profession, and finally promoting and maintaining proper professional standards and standards of conduct for the members of the profession. Then, thinking that through, there are 5 categories that the GMC investigate when there is a concern that a doctor's fitness to practice might be impaired. The 5 categories are misconduct, deficient professional performance, adverse health, criminal conviction or a caution, and poor knowledge of the English language. I'm not going to spend too much time on these, but I think it is probably useful just to give you a few examples of each category of concern that can be investigated. Misconduct tends to be the main one, and it includes a huge range of behaviours. For example, an allegation that a doctor has acted dishonestly, or that they have behaved inappropriately, for example, towards a colleague or a patient. Deficient professional performance, which could be a huge range of things again. For example, an allegation that a doctor has made repeated clinical mistakes, or if they have poor prescribing practices. Third category is poor physical or mental health, and that's something that will be investigated by the GMC, but only if the health condition is adversely affecting the doctor's conduct or the clinical care that they provide, and the doctor isn't seeking or following any recommended treatment or advice. So an example that we see a lot is when a doctor is suffering from issues with alcohol misuse. It's something that the GMC will generally not investigate unless the doctor poses a risk to patients and there's evidence that they're not appropriately managing that health condition. If a doctor is convicted of a criminal offence or if they accept a caution, the GMC is likely to open a fitness to practice investigation. But as part of that, it's also worthwhile just noting that even if a doctor is acquitted at a criminal trial, the underlying conduct that gives rise to the criminal investigation may still be investigated by the GMC, and it would be investigated as a misconduct matter. Finally, in relation to a doctor's knowledge of the English language, it's worth mentioning that English doesn't need to be the doctor's first language, but they must be able to communicate and comprehend the English language to a standard which allows them to practice safely. I think when deciding whether a concern about a doctor raises the question of impaired fitness to practice, the GMC will assess the overall risk to public protection posed by a doctor, and they'll do it on a case-by-case basis. Every single case that we deal with is different, but there are some general principles that I'll just touch on quickly. A single clinic incident involving one patient or one treatment is unlikely to result in the GMC opening a fitness to practice investigation unless that incident is very serious. The GMC doesn't generally investigate a complaint which is more than 5 years old unless they consider it's in the public interest to do so. And once a doctor is referred to the GMC can and often does consider not only the matters that are raised in the original complaint, but they also can investigate any other concerns that come to light during the course of the investigation. So we find that what has initially started as quite a narrow concern that the GMC investigates can become much wider and can encompass much broader aspects of a doctor's practice as the investigation progresses. Just finally, it would be remiss of me as a solicitor to not explain that if a doctor receives a letter from the GMC telling them that a complaint has been received, they really need to contact the medical defence organisation or their insurer immediately before responding to the GMC. If a doctor isn't a member of a medical defence organisation or in receipt of legal representation insurance, or if their provider, for example, is unable to indemnify them, then they should seek independent legal advice. This could be from organisations such as the British Medical Association or from a solicitor that specialises in representing doctors. The second question, which is probably more appropriate for me to deal with as a solicitor, is a question we get asked quite a lot, which is how does a doctor fund their defence? So doctors must have adequate indemnity arrangements in place, which covers the full scope of their medical practice in the UK. Having indemnity cover means that the doctor is insured in the event of a complaint or a claim made against them. The vast majority of doctors will have indemnity cover by way of membership with a medical defence organisation. The type of indemnity cover that a doctor will need is really dependent on their individual circumstances. So, for example, whether they're in private practice or whether they're the owner of a medical facility. If you're a doctor employed by an NHS trust or a GP who provides primary care work under an NHS England or Wales contract, then you will benefit from state-backed indemnity. This means that the doctor is automatically indemnified for NHS services that they provide, and they do not need to arrange their own indemnity cover. However, it's really important to know that this only extends to clinical negligence claims. Crucially, NHS indemnity does not cover doctors in the event that they're referred to the GMC. And this means that the doctor will need to be a member of a medical defence organisation or have insurance in place so that they are covered if a GMC investigation is initiated against them. In my experience, most doctors will have their defence for a GMC investigation funded by the medical defence organisation that they are a member of. And the provider will usually indemnify doctors for all stages of the investigation. So that includes medical legal support, pastoral support, legal advice, representation at the fitness to practice hearing, and any interim orders that might arise during the course of the GMC's investigation. If a doctor isn't indemnified by a medical defence organisation, or if cover is refused for whatever reason, they'll need to privately fund their defence. This situation can and does arise in many different scenarios. For example, if the concern under investigation relates to an incident that allegedly occurred when the doctor was switching between one indemnity provider to another, and for that period of time they were briefly out of membership, which is a scenario that I've seen quite a lot during my career. There's also certain instances where a doctor is a member of a medical defence organisation, but the provider exercises discretion not to provide that cover. Some providers, for example, will refuse to indemnify a doctor who's facing a GMC investigation relating to allegations of personal misconduct, or if they've been convicted of a criminal offence. If a doctor finds themselves in the really difficult position of having to privately fund their defence, then they should also check the terms of any home insurance or professional insurance policies that they have, just to see if that includes the legal expenses cover. And if they do, the doctor might be able to make a legal expenses claim to cover some or all of the cost of legal representation in the GMC investigation. I think I'll hand over to you, Mark. You can deal with the next question. Thanks.
Thanks very much, Georgia. Okay, so the question that I'm going to deal with is, when will an interim order be made? Now, interim orders are essentially the first hearing in the build-up to a fitness to practice final hearing. It's often the first hearing as well that the doctor will be present at. One thing that's important to remember for interim order hearings is that often the investigation into the allegations is at an extremely early stage, really in its infancy, and won't have progressed particularly far. However, sometimes, of course, the investigation can take some time to take place, but also the report to the GMC may take some time whilst, for example, the hospital trust undertakes an internal investigation. An interim order will be made where one, some, or in some cases all three of the concerns and issues that the panel will have to consider are made out. The first one is protection for the public, otherwise in the wider public interest, and finally the interests of the registrant if, for example, there is a health concern or something similar. Now, and another important fact to remember, certainly for registrants, is that an interim order hearing is not a fact-finding hearing. This is not where the allegations will be determined one way or another. The panel is most concerned about risk and risk of harm, as I said, to patients, members of the public, or the registrant themselves. Now, the way that the hearing will work is that bundles will have already been served on the registrant and their legal professional representatives, and the panel will have also received the bundle. Now, the bundle, as Georgia has said, the bundle can sometimes be relatively small, but it can also be extremely large, depending on the stage of the investigation and the sort of case that the panel are hearing. The registrant is entitled, and it is usually encouraged, to provide their own bundle, for example, with information about them, their practice, if they're undertaking any form of training, and also personal references from either patients, colleagues, or similar. What will happen is, at this hearing, as I said, the bundles will be distributed amongst the parties. And it's very unlikely that live evidence, as in either a witness or other, will give oral evidence. The parties will read the bundles and will see either the evidence, statements, or documents therein. It's also extremely unlikely for the registrant to give evidence, and I would normally advise against a registrant giving evidence at an interim order hearing, because once a registrant gives evidence, and if that registrant were then to give evidence that somewhat differs at a final hearing, then that can be used against the registrant. So after the panel hear the allegations and the issues from the case presented for the GMC, the registrant's representative will then make submissions about what the allegations are and if there is risk and how it can be, if there is any, how it can be managed. What happens normally before a hearing is a case presenter and a registrant's representative will speak to each other. The case presenter will tell the registrant's representative what order they are instructed to seek, and they will try, certainly in my experience, the two parties will try to come to some form of agreed position. If they can't, that's a matter for the panel to determine. If the panel hears from all parties, having read the bundle, they will then go into private to determine the issues that have been laid out before them. Normally what will happen is the panel secretary will communicate with the parties to give updates about timing for both sides, to let them know when the determination will be concluded. And importantly, the determination needs to be written up by the panel secretary, and that can take some time, depending on the complexity of the case and the nature of any risk that may be present. If the panel determines that there is a risk, they then have to consider what sort of order is necessary in the circumstances. And it is often either a conditions of practice order, and again, to reflect what George has said, the conditions of practice on one case can be wildly different to another case, and the conditions of practice are drafted in such a way to suit the specific circumstances of the allegations and of the registrant. And more seriously, for an interim order, there is also suspension. However, this is usually only imposed where the allegations are so severe, for example, allegations of dishonesty or inappropriate behaviour. Any order that is imposed can last for 18 months, but it must be reviewed at a review hearing every 6 months, where again, parties are able to make representations in relation to how the order is progressing, how it is working, if it is practical, if it is not practical. And importantly, when an interim order is determined to be imposed, the panel has to impose an order that is first realistic, it is achievable, it importantly meets the concerns raised, and is the least onerous possible for the registrant. The panel has to have consideration for the reputation of the registrant and also the economic and familial situation of the registrant to make sure that they are still able, if possible, to earn a living. And as I said, interim orders are reviewed every 6 months, but sometimes early reviews can be requested by the registrant or indeed the GMC if it is appropriate in the circumstances. So that's my introduction to interim orders, and I'll hand back to Georgia to take on with the next question.
Thanks, Mark. The next question we will address is how to prepare for a final hearing. Preparation for a final fitness to practice hearing is really case specific. It will vary to a larger or less extent depending on the type of allegation that the GMC has brought against the doctor, and also whether or not the doctor admits any of the allegations. There are, however, some general points that apply to all doctors preparing for a final hearing, which I'll touch upon just now. A key part of the preparations is selecting and instructing an appropriate barrister to represent the doctor's case. Once a suitable barrister is selected, the defence team is formed, which comprises the doctor, the barrister, and me as the instructing solicitor. The defence team will meet early in order to devise a plan for how best to prepare the doctor's defence. In this meeting, consideration will be given to the most appropriate case strategy, and tactics for how best to present the doctor's defence at the final hearing will be discussed and agreed between the defence team. Ahead of this meeting, the doctor will be asked to send the defence team all of the evidence that they have. And for this, I always ask doctors that I represent to send me everything they think might be relevant to their case, so that we can review it all and make a decision as a team on what evidence is relevant and should be included as part of the doctor's defence. When preparing for a final hearing, advice that I also give to all doctors that I represent, regardless of whether or not they're admitting any of the allegations, is to read and reread good medical practice, and then to prepare a reflective document on the sections that are relevant to the concerns that are under investigation by the GMC. I think doctors often forget how useful good medical practice is. It's an excellent resource as it describes what is expected of doctors, and it sets out the broad principles that they must follow throughout their medical careers. Even if a doctor doesn't admit any wrongdoing, refamiliarising themselves with the principles set out in good medical practice is a great way for the doctor to show the tribunal that they recognise the seriousness of the concerns being investigated, and that they recognise the importance of adhering to the principles set out in good medical practice, to make sure that their actions continue to justify their patients' trust in them, notwithstanding that they don't admit any wrongdoing in the particular circumstances of the concerns under investigation by the GMC. Another very important part of preparing for a final hearing is remediation. Remediation is a very broad concept, but essentially it's where a doctor addresses concerns about their knowledge, skills, conduct, or behaviour. If a doctor under investigation admits any of the allegations, or if any of the allegations are found proved against them at the final hearing, the tribunal will need to decide whether or not the doctor's fitness to practice is currently impaired. To make this decision, the tribunal will take into account any evidence which shows that the doctor has taken steps to remedy the concerns raised. And they do this to assess the likelihood of whether the doctor will repeat the same mistakes in future. If, for example, it's alleged that a doctor did not obtain informed consent for a patient, to prepare for their final hearing, I would probably recommend that the doctor attends a course on consent, and that they write a reflective document on the course, because this demonstrates to the tribunal that they have considered the concern and they've remediated the concern, which then in turn can show that their fitness to practice is not currently impaired, even if it was at the time that they failed to obtain the informed consent from the patient. I think this is obviously a very basic example, but it's quite useful just to show the steps that we go through when preparing for a final hearing. Remediation is a very long process, and it's really important that doctors think about it at the very outset of their preparations for a final hearing. If you leave it too late, then there's not enough time to truly remediate, and a lot of the time the tribunal will just see it as a tick box exercise, rather than something that the doctors actually put a lot of thought and care into. It's also really important that doctors obtain good legal advice, so that they can structure and tailor their remediation to maximise the rewards and benefit that they receive from it at the final hearing. And now I'll pass back to Mark to answer the fifth question.
Thanks, Georgia. I'll now move on to dealing with what happens at a final hearing, and if so and appropriate, what sanctions may, or how sanctions are decided and what sanctions there may be. So at a final hearing, similarly to an interim order hearing, the evidence will be provided well in advance to all parties, and again, very likely that the bundles for a final hearing will be much larger than an interim order hearing, but again, it depends on the case. What happens practically is after all parties have arrived at the building, everyone has their own conference room that have amenities, and that's their room for the entirety of the final practice hearing. What happens practically when the hearing actually is underway, there will be a panel that has a panel secretary. The panel secretary will read out the allegations as a matter for record, and then what will happen is that if there are any admissions to the allegations to be made, those will be made and confirmed. The case presenter for the GMC then opens their case, and they will set out a relatively short summary of the evidence that they're going to call and what they say it shows, and essentially the case that they are trying to prove. As this is a civil matter, and the test for the panel will be on the balance of probabilities. Also, when the evidence actually begins and witnesses are called because of the forum, what will happen is the witness will be called, all parties are sat down in a room, tables, everyone has microphones, and what will happen is the witness will be there. They will be given a copy of their witness statement or witness statements, along with any documentary exhibits that they've produced in those statements. They will be asked to read the witness statements and confirm that it's their signature, the date it was made, and then that witness statement will form their evidence in chief, rather than them going through the whole of the statement, confirming and reading it all out. Then what will happen is that the case presenter, if they have any follow-up questions or further detail that they need to ask of the witness, they will then start asking those questions of the witness. And that's entirely a matter for the case presenter and indeed the sort of case that it is. After that, the witness will be cross-examined by the representative for the registrant. However, that is much more direct, obviously, as cross-examination, and the witness will answer all of the questions rather than the civil way that it was done in evidence in chief. Again, any documentary evidence that will be referred to will be provided. Uncontested witness statements will be read by the panel in the bundle and can be simply entered into the record by the panel secretary, even if they're not read out aloud. At the end of the GMC case, the registrant's legal representative can then make a submission on the sufficiency of the evidence and their relation to the allegations made. It's what's called a submission of no case to answer. Now, the test here is a legal one. The test is there evidence capable of proving the charge? And that's not saying at this stage that the GMC have, or that the panel are satisfied that the evidence proves the charges. But the test for the panel at this stage is essentially taken at its highest. Is there evidence that is capable of proving the charge? Not that the charge is proven, but is there evidence that on one reading that could prove the allegation? If the answer is yes, then we move to the registrant's case. The registrant will then give evidence, and unlike where witnesses are given statements and they confirm them, the registrant will give a full evidence in chief, where their representative asks them questions that are relevant to the allegations and the background, and will take them through their evidence step by step. After they've concluded their evidence in chief, they're then cross-examined by the case presenter for the GMC. After the registrant concludes their evidence, they can call any witnesses and any further evidence, documentary or otherwise, that is appropriate in the circumstances and admissible. As I said, they are cross-examined by the case presenter for the GMC. After the evidence for the case and really the registrant's case has concluded, what then happens is that we move to closing submissions, and that's where both parties, the case presenter and the representative of the registrant, will give essentially a closing speech and make submissions that are relevant to the allegations put forward by the GMC, and argue on both sides either how the evidence proves the allegations or how the GMC has fallen short. And then after the closing submissions are made, the panel then goes into private, and that's where they make a determination similar to the interim order hearing. It's important to note at this stage also that every decision that the panel are asked to make, and it could be something as simple as either has the case been properly served, or if the GMC want to make last minute amendments to the charges, then every decision has to be made in private and must be deliberated and written up. And as I said, in a normal way, the representatives will usually receive prompts about when the panel will return from their deliberations with the written decisions in note. At any stage as well, it's important to remember that time will be given for both sides if they need time to either take instructions, to look at further evidence, or if they just need some time. Now, after the determination is handed down by the panel, all parties are given a copy. And again, normally they are given time to read the full determinations that can be very, very long, and to importantly absorb what is being said in the determination, what allegations have been proved, what have not been proved, and then importantly, both sides to take instructions about what happens next, because it can happen where panels find that some of the allegations are proved and not others, and the allegations not proved can dramatically change the shape and seriousness of the case. So if allegations are not proved, essentially that's the end. However, if allegations have not been proved, the panel can undertake nothing and simply leave things as they are, or they can provide a warning to the doctor about what has taken place. However, if any allegation has been proved, the panel then has to go on to determine if whatever allegation has been proved amounts to misconduct. And if so, and they find that the misconduct has been proved, then the panel has to then consider impairment. And importantly, the panel has to determine if the registrant's practice is currently impaired, not impaired at the time that the allegations relate to. At this stage, very similar to what George has already said, a key issue for the panel that will help, or certainly something that the panel will be very interested in, will be insights, and will be reflection that the registrant has had about the allegations and what, if anything, they have done since the allegations were made. At this stage, if impairment has been, or if they are considering impairment, it is often that further evidence will be heard, usually from the registrant, because that is the opportunity for the registrant to talk about the circumstances of the allegations, what they have done since then, what insight they have, and what remedial actions, importantly, they have undertaken since the allegations were made. Now, when the panel determines impairment, as I said, if they find there's no impairment, they can take no action or give the doctor a warning. However, if the panel is, if the registrant is currently impaired, that is when the panel will move on to determine sanction. And that's leads me to the final question, which is, how is sanction decided? Now, similar to interim orders, key concerns of the panel is going to be protection of the public, upholding the standards and reputation of the profession, and to maintain public confidence in the profession, but also the professional regulation of that profession. Similar to interim orders, sanctions must be proportionate to the impairment and the misconduct. Key in this circumstance is personal mitigation, insight, and remedial actions, as I've already said, but it is so important, and that's why I've repeated it. Now, when the panel have determined that there is an impairment, the panel then has to move on to determine what action, if any, and which sanction they will undertake. Now, there are several sanctions available to a panel, and that will be a matter for the panel to determine the severity of the sanction relating to the seriousness of the case, and quite often the action and behaviour of the registrant. The first and least serious, obviously, is they take no action. They find that there is impairment, but whatever has happened, they just can simply take no action. They can agree to a written undertaking by a doctor. So, for example, where the doctor promises to undertake some form of training or something similar as that, a written undertaking. They can also impose a conditions of practice order upon the registrant. Moving into the more serious sanctions, they can suspend the registrant from practice for a period of time, and then most serious, left for the most serious cases involving either perhaps dishonesty or misconduct with a patient or with a colleague, erasure from the register. Following the determination of the sanction, again, which the panel will determine in private, and all parties will receive a copy of the judgment, said sanction will not actually take effect until the conclusion of the appeal period. So what will happen is an interim order will be put in place. The registrant has 28 days to lodge any appeal with the High Court. And the interim order will cover the appeal period, but will also take into account the fact that appeals can take some time. So normal interim orders at this stage last for 18 months to encompass the beginning of the appeal process and it's running through the system to the High Court. However, if no appeal is lodged by the registrant or their representatives and that period passes, the interim order essentially automatically lapses and the substantive sanction comes into effect. But the registrant won't, as long as the registrant hasn't lodged an appeal, it will be exactly the same. Nothing will be done in that period. There's no further hearing where the interim order becomes a substantive order. It just happens seamlessly. And as Georgia has already said, and again, I think it is vital to highlight that at any stage in relation to the GMC and the beginning of proceedings moving towards a fitness to practice hearing, from the word go really with interim orders all the way through until that final hearing, early engagement of legal representatives is absolutely essential. It's so important to get your barrister and your solicitors into the picture as early as possible so that they can liaise properly and they can prepare the case as well for you. Georgia, those are all the matters that I wanted to talk about. Thank you so much for joining me. Your insight and your experience of the stuff I have to say that I'm not necessarily so experienced with is absolutely vital and fascinating.
Thank you very much. It's been a pleasure to record this webinar with you. Thank you.
Thank you so much.